And I thought I saw Mr. Anagnostou as well.
Yes, Your Honor, I just got here.
All right. And counsel, I guess first question, there was a order for service by mail. Have we made any progress on that?
Your Honor, yeah, I can withdraw that. That was with regards to the petition, but the petition has been served,
All right.
and so the original petition has been served. At one point it appeared I hadn't gotten Mr. Erickson served, but he has been served. He has counsel, so that can be withdrawn.
All right. So counsel, where do we stand today?
My understanding is we were going to hear from the guardian ad litem today. And that is, I don't see her.
Ms. Farr? I don't either. Let's come back to this one then.
Okay.
Where do we stand?
I filed a motion to dismiss yesterday. I served a copy on opposing counsel. From what I understand, the police were sent to Miss Mitchell's house last night in California.
Do we want to just put that on for the 30th so I can address that motion?
Yes, please, Your Honor.
I'm here on that case, Your Honor.
I'm here on behalf of the mother, Miss Ray.
All right. And Mr. Anagnostou, did you see the filing from Miss Overby?
I did. I think I got that yesterday. And I had a conversation with my client, and we had a conversation with Miss Fellows. In the past, the court has had supervised visitation with Miss Fellows supervising, and we would like to go back to that. My client has a housing issue that she's trying to solve. Currently, she doesn't have housing. And in the interim, she should be allowed to see her children supervised with Miss Fellows. Miss Fellows is willing to do that. And she apparently has a credit because she had paid Miss Fellows in the past for supervised visitation, and she hadn't used up all of the funds that she had provided to Miss Fellows. So she's ready. My client's ready and very much wants to get supervised visitation started.
Ms. Overby, what's your position?
I think that if any visitation is to take place, that it does need to be supervised. We have had a significant increase in behavioral problems and emotional instability since visits have started taking place. And Miss Ray being able to facilitate setting up these overnight visits has frankly been a mess and is causing a lot of emotional drama and stress, in particular for her 11-year-old. And I do not know if visits are even in the children's best interest at this point.
All right. So what I'm going to do at this point is any visits that do take place will not be overnight. They'll be supervised through Miss Fellows' office, and it'll be Miss Ray's responsibility to arrange those through Miss Fellows, obviously with Miss Overby's input. And we'll see if that happens and how those go.
All right.
And I think I can leave it to the parties to note this back on if we need to make any change from there. Mr. Agnostic, would you agree?
No, I would agree. The only question is, how often can she have supervised visitation?
At this point, I'm going to leave that to work out between she and Miss Fellows and Miss Overby. Miss Overby's been pretty accommodating, and I'm sure Miss Fellows will be too. And the burden's going to be on Miss Ray at this point to make arrange those visits and show up for them.
Very good, Your Honor.
All right.
Thank you.
That will be all.
Your Honor, I apologize. I was a couple minutes late and I didn't hear the beginning of this hearing. I'm the guardian ad litem in this matter. And,
yes, ma'am. I'm sorry.
And I wanted to just speak with you a moment about, since the last hearing, Ms. Ray has revoked the ROI for me to get information from her counseling, from CORE, and Ms. Ray also has not communicated with me. I don't know where she's living. I don't know what status is. I don't know what's going on. I've tried to email Mr. Anagnostu and I'm not getting response about that either. So I don't have any information or any contact. I don't have any way to follow up to get records because Ms. Ray has pretty much blocked me out.
Okay, so Ms. Ray, obviously none of those visits are going to happen unless and until you've made contact with Ms. Farr and she's able to get the information that she wants. Do you understand that, ma'am?
Well, Your Honor, since it's supervised visitation, isn't it Miss Fellows that would determine if the visitations are going appropriately with the kids, if there's any inappropriate conduct? Or...
Yes, she will. But in the meantime, Miss Ray's got to get the release of information to Miss Farr so that she can continue to follow up. Miss Overby, look like you got a question.
I do. I have a comment on that. I will say that in a previous filing, I filed a report from Miss Beth Fellows, and she too was requesting, certain stipulations on being able to have visits restarted through Reconnecting Families, as well as I want to confirm that, I have not heard from Miss Ray in regards to setting up visits. She missed her phone call this week and has essentially ghosted.
Well, Miss Fellows is obviously going to be in charge of the actual visits and the conditions for those. But in the meantime, Ms. Ray has to make sure that Ms. Farr has access to the information she needs. So she's going to have to contact Ms. Farr. She's going to have to contact Ms. Fellows.
Thank you, Your Honor.
All right, Ms. Farr is present now, Your Honor.
And Guardianship. All right, Ms. Farr, where do we stand?
So with the Erickson matter, my understanding is that both parents are consenting to the emergency appointment. I have interviewed Dad once. I began an interview with Mom. Mom has been a no-show a couple times, and then she was late to the third interview appointment, and I didn't get very far with her. We've had to reschedule after Thanksgiving to continue that. Dad is currently looking for outpatient treatment. He did relapse in September, and he is now looking to get back into some outpatient recovery treatment. There is DV issues in this matter, and I think both parents probably need some evaluations and treatments for that. Flynn was subjected to these incidences, and he's been really adversely affected. He was self-harming. He was suicidal. We do have a standard petition filed in this. So, as far as visits are concerned, the visits, I think, should be continued as per the counselor's approval and through the counselor, as the counselor deems appropriate. And then either we need to set this for trial or at least extend this out through the end of January. I think it's January 21st is the 4-month period.
Right. Counsel, who wants to go first?
I can go first.
Yeah, sure.
I can confirm, as Mr. Adiknostu has mentioned, that we have received the petitions, and I'm currently working with my client, Mr. Erickson, Mr. Michael Erickson, on our objection to the regular guardianship. We just required some additional time. Mr. Erickson has been fully cooperative in the process. It will just take a little more time to get everything written out and exhibits gathered. With regard to the visitation,
Before you get to that, let me ask one question. On the actual guardianship as opposed to the emergency guardianship, are there any hearings pending on that?
There are
Oh, I apologize. No, Your Honor. The next step on that would be to note it up for trial.
Okay.
I think that's what I would need to do. After we get this emergency part taken care of, that would be the next step.
Understood. I just wanted to make sure I wasn't running into something else.
No.
Go ahead, counsel. I apologize.
Thank you. Yes, and I might also add to that we are intending on inputting our own hearing for the summer because the father is willing and able to act as parent. He just requires some additional time to prepare for Flynn and also not to disrupt the Flynn school schedule. But all that will be outlined in our objection to the regular guardianship, which will be soon forthcoming.
And Mr. Esau?
Thank you, Your Honor. My client initially objected to the petition for emergency guardianship. She's now willing to stipulate and will be preparing a parental consent on that issue, but she's not agreeing to the regular petition for guardianship. And sounds like it's a good plan to get that set for trial so that we have the ability to resolve this sooner than later. So that's my client's position. She's opposed to any visitation by the father because of the domestic violence issues, but apparently that's not going to be available anyway because I think they're both back in Chicago, the Chicago area. So and she's having some trouble with him violating the protection order against her. So against him in the benefit of her. So
okay. So it looks like the next date for this would be January the 11th. I'll extend the emergency guardianship through that date, and we'll set the hearing for January 11 at 10:30.
And visits to remain facilitated through the counselor?
Yes, ma'am.
Thank you.
No other change other than the extension. All right. Thank you all.
Thank you.
Okay. Thank you, Judge.
Excuse me, Your Honor, if I may clarify one thing with Ms. Barr. Ms. Barr, if I may ask, the counselor did seem to require some direction from, I believe, you with regard to coordination of resume visitation with Flynn and the parents. And I just wanted to ask if that's something that you might be able to facilitate.
I'll reach out to the counselor.
Insofar as her recommendations, are you in agreement with them or not?
For it to stay the same. For it to stay the same, I mean, I just want what's best for Christopher. I want him to be heard. If it stays the same, then it'll stay the same, which means I feel like he wouldn't be believed. But, I mean, as far as recommendations go, everything is great other than Christopher not being heard.
Okay. Mr. Sorensen, are you in agreement with the guardian ad litem's position or not?
No, not really. No.
All right, then it sounds like we're going to have to set this for a trial on the motion to modify. So when's our next trial assignment calendar? All right, then the 22nd at 1 o'clock for trial assignment.
Thank you.
Thank you.
And we're on the presentation today. I'm looking, I don't see a proposed order.
Turnaround, I do believe my staff did file that. It would have been on Monday with the bench order, but I do appreciate if the court doesn't have it in front of it. I did receive an email from Ms. Holder, I think, just indicating that and she can speak to this, she agreed to the form of the order, but she didn't agree to. In Section 13, I did request orally at the last hearing that there was standard language that the parties didn't involve the children in conflict or make derogatory comments about the other parent. I don't know if the court made specific rulings on that. So that is, I believe, the only outstanding issue, and then we could circulate for ex parte entry.
Ms. Holder?
That's correct. I just disagreed to the specific language, as I don't believe the court found anything having to do with what was in Section 13.
Okay. I prefer that language in there anytime there's disputes going on, just as a reminder to everybody. Do you want me to put this over 2 weeks since there's no Thursday docket next week? Or can I just go ahead and sign it then with that ruling?
Ms. Holder, do you think we can get that agreed, or?
If that's what the judge wants and he wants that specific language inside the order, I think it's fine for him just to sign it now and not have to set this over anymore.
All right. I will sign that order as soon as I see it. Parenting plans proposed. Ms. Brooks, anything you want to say in addition to what's in your paperwork?
The only thing that I didn't know if I needed to submit a new one or not, but his schedule recently changed, and he's working shift work at the mill, so he works 4 days, 4 nights rotating. And the last parenting plan that I submitted was every other weekend, but that's not really doable on his end anymore. So
what are you proposing at this point?
I was proposing just kind of switching it a little bit to his first 2 days off every other week. So he's still getting 2 nights with her, but it's not the weekends because that's just not really doable for him.
And Mr. Peak, what's your position?
I think I showed in my parenting plan, I would like to have her at least 3 nights. Well, 50-50, however that's possible with my mill schedule. Because I do 2 day shifts, actually, and then I get 24 hours off, and then I work 2 night shifts, 12-hour shifts. So I get that in-between day, but depending on overtime, but I could figure it out. I was just wanting 50-50 custody. Like, I think I asked for the week on, week off is what I was wanting. If it was a lot, yeah. But just share custody where we could somehow make it work 50-50 depending on, like, my schedule is hard to deal with, but I could make it work.
Okay, so here's what we're going to do. Based on what's been presented to me, I'm inclined to follow Ms. Brooks' proposed schedule. That's going to include the provision that, Mr. Peak, you're not to drink when you have the child with you. We also need to sort out the child support. So you're both going to have to fill out financial statements and the child support worksheets, a proposed child support order. So make sure you cooperate on that, provide each other your pay stubs so we can get that taken care of. In terms of the parenting plan, it's nobody's fault, but the mill parenting plans are real difficult to work out, especially for me sitting here not having the exact schedule in front of me.
Okay.
What I'm going to do is I'm going to put this over for 2 weeks to the 30th. In between time, Mr. Peak, I need you to submit a calendar that shows your schedule. And I want the two of you, if you can't agree on how that, the equivalent of every other weekend would work, then I want each of you to give me a proposal in writing for how to make that work. And when we come back here on the 30th, if you don't have it agreed, I'll come up with one. Is that enough guidance for both of you, Ms. Brooks?
That is, I just have 2 questions. My first one is I already did submit like the financial declaration and all of that stuff. Do I just need to redo it, or do I need to, I believe I submitted it back in July when I
Okay, I've got your declaration. I don't think I have one for Mr. Peak.
Okay.
And
yeah, mine changed my pay rate. It keeps changing. Yeah.
You know, and ma'am, then I also need the child support worksheets and a proposed child support order.
Okay, I think I did that as well. Am I allowed to just refile the exact same documents, or do I need to refill it all out?
Hang on, let me look through here, because all I have got is the your financial declaration. Okay, it wasn't in the system, but I've got a written one here. So, Mr. Peak, have you had a chance to look at the proposed child support worksheets and the child support order?
Yeah, I was able to take a look at it. I did have a question about that.
All right, go ahead.
I think she or Haley proposed it was what, $600 a month?
Let me look here. Yes, sir.
Okay, and I just had a question because I was in my proposed parenting plan. I was asking for 50/50 subsidies, but right now I'm paying like half of all other, like tuition, other stuff like that. If I was court ordered child support, then I would just pay the child support and not the half of the other amendment or stuff I've been paying for my daughter. It would just be that payment to Haley.
I'm sorry, I didn't understand what you're asking.
Well, because we've been like, her school is going we pay a 50/50 like on tuition for her school.
I was building the fire and I had the door open to get some wood and the paper took off its own.
Okay. So you're still responsible for a percentage of certain expenses. Okay. Those generally include school, the usual sports kind of things, uninsured medical.
Okay. I was gonna I saw the 600 up for when I looked at all my bills and everything. I was gonna suggest 300 is a possibility, and then plus still paying for the tuition and everything like that.
Has she accurately listed your income in the worksheets?
No, I just did a guess on it.
So what are you earning now, Mr. Pete?
What am I earning, like hourly?
Yes.
My hourly, I think, is, I don't know the exact, I think it's $27.70 or something like that is my.
All right, well, do this. Get a pay stub to Miss Brooks. Miss Brooks, do an amended set of worksheets and child support order based on that. So we can try and get it accurately as possible. All right?
Okay, and then so on the temporary, I don't know.
I wanted to bring it up,
but I was asking for a reimbursement for her childcare because he's not paying childcare at all. Because he's saying that she's not with him, so it's not his responsibility to pay for it.
Well, I have a question about that as well.
Hang on just a second. Let her finish.
And it's $200 a week, and I just went back to work from maternity leave on the 25th of September, and I have paid, I want to say $1,400 to $1,500 to this date, and I owe $200 more tomorrow. And it's just kind of like becoming a financial burden, like him not helping with that. Okay. And so that's a huge thing that I am hoping to get either reimbursement on, or I don't really know what to do. He's just not helping in that.
All right, Mr. Peak, what's your position about that?
Well, my question was, so since the other case we have going on, I've only been able to see my daughter one time, and she hasn't allowed me to, because there's been no parenting plan in place. I've only been able to see my daughter once since the temp was denied, the temporary protection order was denied, I think, by you. I've only been able to see her once, and I've been trying to see her. I have no problem paying for childcare, but it's not paid to the state. It's paid to we have a daycare, or we have a person we know that takes care of her. It's like $45 a day.
All right. Well, childcare, so both of you can work, is part of what's contemplated by the statute governing this. So you're going to be paying your percentage share of that, and that should be included in the child support order. Hopefully between now and the 30th, the two of you can look at your schedule and figure out as close as you can the equivalent to every other weekend. If not, I'll address that on the 30th. But ma'am, when you prepare the child support order, include your percentage shares of the daycare expense in that order. All right?
Okay, I will do that. And then just because I just don't like to say things if I don't have proof. So, like, I don't want you to think that I'm withholding my child from him, and I have proof.
Yeah, I'm not addressing that right now. I want the two of you to try and sort it out if you can. Great. If you can't, I'll do it on the 30th, all right?
Present.
Okay, thank you.
I'm here.
Thank you both. Okay.
Good morning, Your Honor. Casey Looney for the state on behalf of child support.
And Ann Height, guardian ad litem, Your Honor.
So have you both seen the state's proposed child support order?
Yes.
Yes.
And ma'am, do you have any objection to that order?
No, I do not.
Mr. Tafoya, do you have any objection to it?
Can I review what the quantity is on that? Because I don't have it in front of me right now.
I can do a rundown of the numbers and how child support was calculated if you like, Your Honor.
That would be great. Thank you.
So we looked at Mr. Tafoya's last 4 quarters of income. That's through the second quarter of 2023. And additionally, we did apply a full family deviation because he does have one other child aside from the 3 children in this case. So we have a net monthly income for him of $3,412. We have imputed Ms. Tafoya as a TANF recipient, so that's minimum wage, 32 hours a week, with her net income being at $1,953. With the whole family deviation applied, the transfer payment from Mr. Tafoya to Ms. Tafoya would be $973 for all 3 children. That would be $325 for Justice and $324 each for Riker and Knox.
You understand that, Mr. Tafoya?
I do. And I absolutely agree with needing to pay child support. You know, I've been paying child support for my eldest. He's 16 now. 900 is for me with my I know it's calculated out. Like I should be able to quote unquote be able to cover it and pay for it, but that would currently crush my living situation. I purposely went out of my way to try to get a 4-bedroom house for rental, and it's on a little bit of the steep side because it had to be a 4-bedroom, but it's the cheapest one I could find in Vancouver. And if I have to pay that much, the likelihood of me not being able to keep this place of residence is rather high. And that's the most honest way that I can put that.
Your Honor, I don't know if the parents had specific requests, but I did also want to note that we did leave the tax section on section 19 on page 5 included if addressing claiming the children on taxes might be something that Mr. Tafoya would want to do, but the state has calculated his child support as low as we possibly can under the law.
Yeah, Mr. Tafoya, the child support kind of is what it is under the state law. Ma'am, do you have any position about the tax exemption for the children?
What him and I had discussed before was that for the twins, one of us would claim one year, or he would claim one of the twins and I would claim one of the twins every year, and then we would alternate justice. That way we each had, because the twins are 3 and then Justice is 4.
Okay, from the looks of things, frankly, I don't think the exemption for you is going to get you anything. You'll be filing as head of household, and given your income, I don't think it's going to do you any benefit.
I worked for the as a nanny for half of the year this year, and so I claim taxes on that. And if I don't have the exemption, then I end up paying if my exemption ends up.
Ms. Loney, does that sound like to you that given her income at this point, that it's not going to be of any benefit to her if she files as head of household?
Your Honor, I don't believe so. I believe you are correct, but I don't have those numbers specifically.
So, Mr. Tafoya, I'm going to give you the tax exemptions for the children every year, at least at this point. Ma'am, if your income changes, that could change your situation. So you're free.
Because I'm no longer on TANF as of this month.
I understand that. But you'll still be filing as head of household. And with that, I don't think the exemption does you any good.
Okay, well, I'm going to end up owing on my taxes then is what I'm saying, because the tax exemption for the kids is what covers what I should have paid in taxes for my nanny job.
I think by the time you file, you're not going to owe any more. The exemption won't make any difference for what you do or don't owe. That's what I'm saying. Because when you file as head of household, given your level of income, you should be in good shape with the IRS.
And Your Honor, I just want to remind the parties that this is just a temporary order, so they can adjust as needed when they finalize their case.
Yeah. So if it turns out I'm incorrect, certainly bring the matter back. Understood?
Yes, I'll contact my tax lady today.
Okay. All right, and with that, then I will sign you Mr. Pittman's declaration.
Yes, I have.
All right, Ms. Main, anything else you wish to say in support of your motion?
Yes, Your Honor.
Go ahead.
I prepared. I'm going to say. So, Your Honor, I was married to this man for 20 months. And I did so with hopes of a future together, only to learn such in a short time that it was based on lies and deceit from day one. Not only can he not be honest with his wife and children, he can't even tell the truth in a court of law. As per his own words and my evidence submitted, it shows by a preponderance of evidence. And I would like the court to grant my restraining order. My evidence submitted, incident A23-18241 from 8/21/23, when he threatened suicide in front of all the children, in the prior protection order case that was denied on 10/23/23. He stated to the court he was getting fish. I'll read directly from the incident. A23 it's okay. 18241. This was submitted to. This was the suicide report. Mr. Pittman stated that he was frustrated due to medical and financial issues. He said he isn't suicidal and was provided an emergency mental health card by the sheriff's department, and threats of suicide not special to this incident. This is the only one I had reported when he doesn't get his way, is when he threats and pulls knives out in front of my kids, his own daughters. Go ahead and read it. I have reported when he doesn't get his way with this, what he does. I provided messages from Saban, his older daughter's mother, with reports, and also Tracy Johnson, the one that raised his two daughters. I mean, it's okay, calm down. There was messages states that the girls thought he offed himself because they couldn't reach him by phone. The day I got the courage to leave him, because the behavior was normal even to his children. I'd like to read directly from John Pittman's own declaration. I will get to that in just a minute.
Right. Anything else, ma'am?
As for his mentioning my previous custody battle with a child that I share custody, that the whole case for my side was dictated by John Pittman and his narcissistic manipulating behavior. He has mental problems that need addressed, sexual, psycho evaluation, and I'm scared to death for him, my safety and my children's safety. He comes from a family of 4 siblings. 3 of them, including, are convicted of sex crimes upon children. In order to do a mental and sexual evaluation by the court, Your Honor, I'm scared to death of him and my children's safety. So respondent, Mr. Pittman, stated in his own declaration, and he's the petitioner, and has a way to, be in control. When he was served the immediate restraining order documents, he states that he was not served with a hearing notice. There's also proof from the court that you gave the order to. He was served. There's proof of service by Ralph Carrera in Colima Police Department.
Served?
Was served.
The immediate and court hearing.
He was served the immediate and the court hearing.
Your Honor, I do need to object to, I believe it's Miss Pittman's mother, Miss Maine's mother, directing her.
Yeah, Miss Maine, whoever's there with you needs to keep quiet. I just want to hear from you.
Okay. So he states that he was never served. He claims that he was only gutting fish. That he's lying to the court.
Anything else, Miss Maine?
I'm just emotionally distraught. And just put myself and my family safe.
Miss Holder?
Your Honor, has the court had a chance to look over the denied protective order in the first case from earlier in October?
Yes.
Okay. Then I won't need to rehash the issues from there. Ms. Maine is asserting many of the same issues that there has already been an order that was denied, and this is her trying to take a second bite out of the same apple. And the reason that she was denied in October, on October 23rd, was because of insufficient evidence. So she now comes back to this court alleging the same facts, or relatively the same facts, with some additional information that is objectionable because the text messages she's put forward, there's no context. They're an amalgamation of both text messages and handwritten notes. There are police reports that do not prove anything beyond a preponderance of evidence by what Ms. Maine is saying, but rather what Mr. Pittman asserted at the first hearing back in October, which is that Ms. Maine has a habit of calling the police show up, and nothing happens. There's no wrongdoing. There's no probable cause for an arrest. There's no follow-through with a conviction. What Ms. Maine is doing here is she is circumventing the courts, and she is trying to leverage herself in another custody fight. As you can see from the other protective order that she filed against the father of one of her children, Ember, that was filed against Mr. Christian Witt, there was a prolonged custody battle with that, which Ms. Maine is now alleging that my client orchestrated, which that was not in any of her declarations or the petition. So I would object to that. But that protective order was rescinded due to the fact that she admitted herself this is due to a custody fight. And it was in conjunction with us fighting over custody of our daughter, which is what she's doing again here. Mr. Pittman has not seen his son in almost 2 months now. And he's followed every court order. He followed the first one. And then she immediately, the day she lost, filed a new one alleging the same facts and not putting forward any new evidence. And so for that reason, we would ask that this immediate restraining order be dismissed. Further, I think it is very indicative that she didn't file him with a hearing notice. We had to look it up in my office offline to be able to tell him, yes, there's a hearing on this, because she did not set a hearing for any of the other issues she put forward, including her parenting. I believe she put forward a proposed parenting plan, the petition for divorce. None of that was to be heard except for the immediate restraining order. And again, that's to drag this process out and to leverage the situation so that my client will not be able to see his son. So again, this is just, this is an effort on Ms. Maine's part, and I believe also on her mother's part, to circumvent the courts and to prolong this situation longer than is necessary to keep my client from seeing his son. Further, if Ms. Maine and her family were really in fear for her life, there is no reason that Miss Main's mother should be harassing my client, driving past his home, taking flash photography, stalking him to the point that she had to get a no trespass order. So she is either in fear for her life and the life of her loved ones, or she is not. And if that is the case, she has perjured herself one way or the other. So again, we would ask this petition be dropped.
Ms. Main, anything you wish to respond to?
Yes, I would. So again, for proof of service, and he was approved, that was provided, there was proof of that. Also in his declaration stating that his neighbor has giving him information about my whereabouts and when I'm coming to my house, and saying that I moved out of my residence, that's absurd. That's my place. But for somebody to give information back to the other party about me, I just don't think that's necessary, and it makes me feel really uncomfortable.
Your Honor, may I respond?
Well, I think I've got enough at this point. I'm going to deny the request for the emergency no contact order. I will enter an outside the box order that says these parties are to correspond only through Ms. Holder at this point. I don't have the matter on today to enter any sort of parenting plan. However, it's obvious to me at this point that we need to get a guardian ad litem appointed as soon as possible. Can you give me the next three names?
Amy Treble, Ann Height, and Twyla Corey.
All right, so Ms. Main, if you'll contact Ms. Holder, and you can either agree on which one of those three should be the guardian ad litem in this case, or you can each strike one name and take the third one. How you do that is strictly up to you. Ms. Holder, if you'll prepare that order and get it filed right away, I will sign it, and we can get the guardian ad litem process started as soon as possible. And I'll leave it to parties to note the matter up for parenting plan.
Absolutely, Your Honor. And may I get an oral order that directs Ms. Main to exchange custody or to arrange a visitation, at least with Mr. Pittman and his son?
I thought of that. I'm not going to at this point. Ms. Main, given the age of the child, it is important that he see his father, but I don't want the two of them making contact to do it, and I don't know who a rational third person would be to have involved. It doesn't sound like her family would be appropriate. So, Ms. Main, what I'm saying is work with Ms. Holder to set up some time through some sort of third party that you can both agree on for Mr. Pittman to see the child. Understood?
I don't have any.
Let's talk to Ms. Holder about that, and we'll see if we can find somebody to do it.
And Your Honor, may I also get an order on attorney's fees? I forgot to ask that for that in my oral argument, but it was completely unnecessary to go through this process.
We'll reserve on fees at this point.
Thank you.
All right. Thank you all.